Well, it's Friday of a short work week for those of you who had the 4th of July off. Some of us work through the week, and we are entitled to a sense of relief that today's Friday, but that means tomorrow is Saturday, which means there's no court, and that's another good day in the office. Wait, there's something wrong with this picture. I want to be living Mike's life. I get there's some more. Welcome back to Law and Legitimacy, everyone. It's Friday. Happy 4th of July week. So I get pictures this morning. I don't know how it happened, but Mike, they're beautiful pictures of a lake somewhere south of the Mason-Dixon line in North Carolina. And he says, from the jet skis. So I have this image of a guy on a jet ski with his camera trying to take pictures while trying to stay afloat. He did it somehow. How's vacation down there, buddy?
It's awesome. It's awesome. It goes too quick every year. It's already Friday. We'll get out of here in the next couple of days, but it's been great. It's been great.
Well, it's been, thank you for making time for us. So, my phone's blown up. I've got to ignore certain calls, and I am. And so take a look at the news today. We missed this the other day. It's been a busy week, but the state of Missouri and others have filed a case against Joe Biden and others, basically saying, stop being a censor. Keep your finger off the internet. The case is called State of Missouri et al., which means and others, versus Joe Biden and others. And we're going to talk about who some of those others are in a moment. It is pending in the United States District Court for the Western District of Louisiana, the Monroe Division. And the judge is Terry Doughty, Doughty. Judge Doughty did something extraordinary, and he entered a preliminary injunction enjoining an order stopping others from trying to determine what you can and can't read. Who are the defendants? Listen to this. The Department of Health and Human Services, the National Institute of Allergy and Infectious Diseases, employees of HHS, that's Health and Human Services, including Dr. Hugh Auchincloss, director of the National Institute for Allergy and Infectious Diseases, Xavier Becerra, secretary of HHS.
Becerra.
A whole series of other people whose names I won't mention, but I will mention some institutional affiliations: the Centers for Disease Control and Prevention, the United States Census Bureau, the Federal Bureau of Investigation, including Laura Demlau, Section Chief, FBI Foreign Influence Task Force, the United States Department of Justice, with their secretary, director, administrators, and employees, the following members of the Executive Office of the President of the United States: White House Press Secretary Karine Jean-Pierre, that historic figure, counsel to the President, Stuart Delarey, White House Partnerships Manager, Aisha Shah, Special Assistant to the President, and a number of others, including Ali Zaidi, the National White House Climate Advisor. I didn't know there was one. Turn up the air conditioning, Joe. It's warm in here. Thank you, Ali. I'm glad I hired you. The climate's tough. Clark Humphrey, the guy named Benjamin Wakana, not to be confused with Benjamin Wakanda, Deputy Director of Strategic Communications and Engagement in the White House, White House COVID-19 Supply Coordinator successor, Timothy Manning, Chief Medical Advisor to the President, the Director and all employees of the cybersecurity and infrastructure people, and the list goes on and on and on. And what are they prohibited from doing? They are prohibited from meeting. Well, let me read some of the prohibitions. Meeting with social media companies for the purpose of urging, encourage, pressuring, or inducing in any manner the removal, deletion, suppression, or reduction of content protected by freedom of speech, flagging content or posts on social media or other media companies, urging, encouraging, pressuring, or inducing in any manner the removal, deletion, suppression, or reduction of content. They're prohibited from encouraging, urging, pressuring, or inducing in any manner social media companies to change their guidelines for the removal, deletion, suppression, or reduction of content containing protected speech. They're prohibited from sending emails, blah, blah, blah. It goes on and on. It's pretty amazing. Now, the order goes on to say, look, they can enforce the law. And if they see somebody about to break the law, we're not asking the FBI to go home, to pack up its search warrants and its guns and badges and go to the beach with Mike. But what the court is saying is that when it comes to speech, the government should not have a role in content-based suppression of speech because government agents regard it as
Yeah.
disinformation
So
or
if we could back up for just a moment, Norm, I don't know if you knew that there's a memo from the court on this, and this was sent to me earlier this week by one of our viewers. The actual memo on this ruling. So what I have on the screen is obviously the 2 or 3 page order from the court, the judgment giving partial granting of the preliminary injunction, partial denial. That partial denial was as to some of the parties or some of the defendants, right? So not all of the defendants named in the lawsuit are enjoined from the conduct that you just talked about, but the memo on this is just as interesting, and it's 155 pages or so. But I want to give a few remarks from the intro from the court. It starts with a quote, and you'll appreciate this, Norm. I may disapprove of what you say, but I would defend to the death your right to say it. That's, of course, Evelyn Beatrice Hill from the Friends of Voltaire, circa 1906. And it says, this case is about the free speech clause in the First Amendment to the United States Constitution. The explosion of social media platforms has resulted in unique free speech issues. This is especially true in light of the COVID-19 pandemic. If the allegations made by plaintiffs are true, the present case arguably involves the most massive attack on free speech in United States history. In their attempts to suppress alleged disinformation, the federal government, and particularly the defendants named here, are alleged to have blatantly ignored the First Amendment's right to free speech. Although the censorship alleged in this case almost exclusively targeted conservative speech, the issues raised herein go beyond party lines. The right to free speech is not a member of any political party and does not hold any political ideology. It is the purpose of the free speech clause of the First Amendment to preserve an uninhibited marketplace of ideas in which truth will ultimately prevail, rather than to countenance monopolization of the market, whether it be by government itself or private licensee. Plaintiffs allege that defendants, through public pressure campaigns, private meetings, and other forms of direct communication regarding what defendants described as disinformation, misinformation, and malinformation, have colluded with and or coerced social media platforms to suppress disfavored speakers, viewpoints, and content on social media platforms. Plaintiffs also allege that the suppression constitutes government action and that it is a violation of plaintiffs' freedom of speech under the First Amendment to the United States Constitution.
I mean, that's a hell of a ruling. And the thing that amazes me about the case is we called this in our New Year's Day show where we talked about what we'd be watching for this year. And one of the things we said we'd be watching for was the public health state's attempt to control speech in the name of misinformation and disinformation. So kudos to the group that brought this. But here, I want to raise some serious questions, though. So, when I go to the doctor, I assume that this person has an MD, that they're licensed, that they remain current, that their license is in good standing, and that they're acting within the standard of care, meaning they're remaining current on developments in their field and on the latest diagnostic attempts and whatnot. So when I've got aches and pains, I go to the doctor and I place my trust in the physician. And that trust is, when I say I go to the doctor, I haven't been to the doctor in like 5 years or more. But the next time I go to the doctor, I'll be doing that. And I'm going to either take what he or she has to say at face value. In other words, do what he or she says or not, depending on what I think. But one thing I'm not going to do is I'm not going to second guess them. And I'm not going to say, my lay opinion is better than your professional judgment. And so I want to raise this question, Mike, because I think it raises profound First Amendment issues, and this case illustrates it. What we have as defendants in this case are a group of government officials, presumably dedicated to standards or norms of producing reliable information about the public health system. And what they want to prevent is that misinformation or bad information be distributed to the public, thus undermining the public health. That seems to me to be a worthy goal. And it seems to me that if we're going to recognize that there are folks that have expertise, we owe it to ourselves to listen to them. So I guess what I like about the judge's ruling is he's saying, look, I'm in favor of freedom of speech. What I like about Judge Doughty's ruling is that it favors freedom of speech. What I don't like about it is it begs the more interesting question. And that is, does government have a role at all in certifying that some things meet certain methodological standards and others don't? So, what's your response to that?
Well, I think it's a great question, and I guess I start with what the order says is specifically prohibited from or excluded from the preliminary injunction, because I don't think that we covered that in the opening. So it says in the order itself, it says it is further ordered that the following actions are not prohibited by the preliminary injunction. One, informing social media companies of postings involving criminal activity or criminal conspiracies.
Okay, that's clear. That's always been an exception to protected speech.
Yep. Number two, contacting and or notifying social media companies of national security threats, extortion, or other threats posted on its platform.
That's a little bit more amorphous a category. I don't know what a national security threat is, but there's well-developed case law around statutes that give the government the right to make that determination. So I'm a little
The lights have just been
uneasy.
turned off on me here. Maybe I can come back on it.
Yeah. No, that's great. I'm a little uneasy about that, but I can live with it. What's the next one?
Number three says contacting and or notifying social media companies about criminal efforts to suppress voting, to provide illegal campaign contributions, of cyber attacks against election infrastructure, or foreign attempts to influence elections.
So that's really just a subset of 1 and 2. It doesn't really add anything. That's just a point of emphasis.
Yep. And then let's see, number 4 here, informing social media companies of threats that threaten public safety or security of the United States.
Again, that's a distant cousin of number 2. That's a traditional law enforcement function.
Number 6, informing social media companies of postings intended to mislead voters about voting requirements and procedures. Number 7, informing or communicating with social media companies in an effort to detect, prevent, or mitigate malicious cyber activity. Again, more vague and amorphous. Number 8, communicating with social media companies about deleting, removing, suppressing, or reducing posts on social media platforms that are not protected free speech by the free speech clause in the First Amendment to the United States Constitution. So number 8 is interesting to me, and I think it kind of gets at the original question that you posed here, right?
Well, suppose so if I'm a doctor and I tell people swallow Clorox, that will kill the microbes within you. Without telling you, it'll probably also kill you. I've undoubtedly acted outside of the scope of my authority, and I may face regulatory problems from the Board of Health Examiners or whoever governs me in my state. But suppose I'm a layperson and I make the same statement. Now, I might recklessly be making statements knowing that they could cause a person harm. So let's make it a little bit more interesting in the ivermectin cases. If a doctor prescribes ivermectin, but the American Medical Association and the Centers for Disease Control and the Department of Health and Human Services believes that this is contraindicated, that is, that it's not efficacious and that it's going to hurt a person, doesn't the government have a responsibility to say something there?
I think it does, but I think what's happening with this case, Norm, is I believe what I've talked about before, and I still haven't really come to a way to articulate this in as concise a way as I wish to. But the issue that we're battling right now, to me, in terms of if we're stringing this theme of legitimacy as often as we can, is when institutions make decisions that there are credible counterweights to, but they do so in a manner that basically that undermines public trust, but public trust can only be restored by and through the courts. And what you and I know is that remedy through the courts is a very delayed remedy in and of itself. So it's not so much that the issue won't be resolved, it's that the issue won't be resolved in a timely manner. It's a race against time right now. Social media has made it such that those who control the levers of power, those who control the influence over the basically monopolized social media landscape, whether it's Facebook, whether it's Instagram, which is owned by Facebook, whether it's Twitter, whether it's YouTube, which is owned by Google, if they have made the decision to march in lockstep policy-wise and suppress information that is otherwise credible, because what I had on the screen before I switched over was this factual background that talks about the plaintiffs and what their expertise ultimately is and the basis for why they would want to bring suit. The issue here isn't whether the plaintiffs are made whole, and in this instance, it's necessarily larger society, because as T Girl has said in the chat here, they effectively suppressed getting a second opinion when it came to COVID treatment. My issue narrowly is trying to figure out a way to communicate this, and perhaps you and I can work together on this. But delayed remedy was never as big of an issue as it is now, and I mean that delayed remedy through the courts. When these things happen,
I agree. And hence the credit to Doughty for prompt action on this request for immediate temporary injunctive or injunctive relief immediately. But I mean, here's I want to distinguish between scientific speech and political speech, and I recognize there's going to be an overlap, especially if the 70% of the scientific community.
One might also say that overlap is what has allowed the censorship to begin with, right? One might argue that on behalf of those that claim the mantle of science, right, they have actually used that leverage of the overlap between science and politics to distance themselves from politicization, because they do control that apparatus. And so they say that our view is the scientific view. The other view is the politicized view. And as such, we are to be deemed credible and trustworthy. And even if what we're saying is perhaps somewhat credible, somewhat trustworthy, theirs is wholly not, right? Their view is wholly not.
And so at the margins, there are going to be difficult cases. I think there are easy cases like the swallowing of Clorox that arguably might be criminal. I think that this case represents.
So say more about what do you mean from the Clorox perspective?
Telling somebody to swallow a poison that it's good for them is problematic in any.
But wasn't that a hoax as it pertains to COVID?
I'm not talking about historic facts. I'm trying to sketch out the metes and bounds of this doctrine to illustrate a larger problem that I'm concerned with, and that is the regulation of speech and what to do with misinformation, because I think there is misinformation, and I do think that people spread lies, spread things for purposes of disruptive. That's a known espionage technique to disrupt a society by doing that. I mean, J. Edgar Hoover is famous for that, for having done so with Martin Luther King, for having done so with the New Left, where they would spread lies or disinformation in order to disrupt people. So our enemies may do that. Well-meaning people in society may do that. I think the problem for me is reflected in the growing distrust of expertise per se, because I do think there is an external world that is independent of our wishes, desires, and perceptions, and I do think it can be known. And I think history shows that in the form of the scientific revolution and in terms of the industrial revolution and the transformation of our society. So if there are methods and techniques that permit us to know the truth or to know a truth, and it's government's responsibility to assure the health, education, and welfare of us all, at least that's the argument, that's why we've created it, doesn't that carry with it, I don't want to say the right, but the responsibility to try to educate the public about what the truth is? And if there are those in government who have expertise that the rest of us don't share, who believe that the things that aren't true are being spread and causing harm, shouldn't the government have a role in stopping that? And I'm playing devil's advocate. Maybe they.
Yeah, I recognize that you are, because what's been demonstrated wholesale through this entire saga over the last several years is that top-down coercion is to the exclusion of other more viable remedies, and also to the exclusion of individual sovereignty, right? And our entire republic system is built on localism and local politics, and it's built on that forced inefficiency through Congress. And I recognize that the executive branch has certain emergency powers, and I recognize that the judicial branch is not responsible for, it doesn't have power of sword or purse, respectively, as it pertains to the executive branch and the congressional branch. But I do think that people, by and large, are better situated individually to make decisions in their own best interest. And
Well, let me play. I'm playing the devil's advocate game very hard here for a moment. Let's assume that there'd been no laws or regulations on the regulation of tobacco and tobacco advertising. I think there's a pretty well established science, and that's an assumption. We know that to be untrue. Go try to buy a pack of cigarettes, and you'll read the warning on the side. Forget about that for a moment. Scientists say smoking is bad for your health. The tobacco industry says it's not. Should the tobacco industry be prohibited from putting on their packages "smoke and live longer"? And if if social media is endorsing that point of view, don't those who know better have they have the right certainly to say something? Maybe not if they're the government. But shouldn't government have the responsibility for educating us about what's in our own best interest so that we can make informed decisions?
Well, in the case of tobacco, how long was it before the government began to actually make moves to that end, to actually force labeling guidelines that were in the affirmative as to hazards related to cancer, hazards related to inhalation of tobacco while pregnant, and the relationship between that and birth defects? It wasn't overnight. Certainly, it was a years long campaign. I grew up on
decades.
right, and this is something that and this was due in large part to the monopolization of that market and the powerful lobbying power of the likes of the tobacco companies. And this is evolved out of the 60s, where we now know that doctors were prescribing cigarettes as remedies for certain certain issues that
Man, I will never forget, Mike. Your parents hadn't even. I'm probably older than your parents. I'm so old. I remember as a kid once going to the doctor's office because my mother didn't take me to when I cut my finger. He says, how come you didn't get this stitched up? It was like swelled up. I said, my mom told me not to do it. He says, mother's jobs are to bake apple pies. I'll tell you whether you need stitches, while dragging on a cigarette while I'm sitting there. And he weighed about 100 pounds too much. And I took a look at him and I'm thinking, I'm listening to this guy about my health.
Exactly.
It smells like hell in here. Well, and he looks like he died 7 months ago. Now, having said that, I should have had the stitches. I just raised this because I think the question of science, and scientific truth and the legitimacy of what experts have to say and
again,
government.
T-Girl gives us more to chew on here, but this isn't something that's new. It's just prompting some recollection on our part here, Norm. It's deaths of despair. Where is big government on the opioid crisis? Where is the government in terms of guarding people from not only their addiction to that drug, but also the proliferation of other drugs, other hard drugs?
So does the fact that government performs a role imperfectly mean it shouldn't try to perform it at all?
Well, no, because here's the main issue with that. These are the same pharmaceutical companies that are responsible for OxyContin, and I sound like now I'm like taking a page out of RFK's script from the other night, but that doesn't make it any less true, right? These are the same companies. These are the same companies that are producing OxyContin, that are producing the opioids, right? That are bringing in other ingredients for use in the medical profession. Are the same ones that are pushing through not only applying for patents on gene altering therapy, mRNA, et cetera, but also pushing for widespread vaccine use, and it's in a very acute time frame. So I think the issue is
Friday, and I'm obviously scattered. But how did we go from talking about oxy companies, from talking about rather the government's ability to suppress speech on social media, to talking about what oxy companies want to sell us?
How? Simply because again stringing this theme of delayed remedy in the face of obvious violation of rights. And in this case, we don't have to look very far to see where, for example, Joe Rogan was, his image was taken by CNN. It was altered to make him appear more sick. And then he was defamed in real time because he chose to go through an alternate path to treating his COVID, right? His diagnosis of COVID. Right.
So let's just bracket the issue. I think, because we got to move on, state of Missouri versus Joe Biden et al. Keep an eye on it. It'll be in front of the Fifth Circuit Court of Appeals in a heartbeat and probably go up to the United States Supreme Court. The marketplace of ideas notion that is the primary justification for the First Amendment talks about free speech as a means of determining what's true. The question presented in this case will be whether there's some forms of speech that are so beyond the truth-finding function that they constitute little more than garbage and ought to be suppressed. And I expect that issue to be framed in a more scholarly way for the court and soon. But it won't be framed by Lin Wood. Lin Wood is, he was a former Trump lawyer, and he got behind the Stop the Steal litigation, filing papers in a number of states. And I'd heard disturbing reports about Mr. Wood. Mr. Wood has agreed to give up his law license. He's agreed to retire after he was attacked for advocating on behalf of President Trump in 2020. I'm disturbed by that. Because I think that in the same way that government ought not to be regulating ideas and regulating speech, bar regulators ought not to be punishing clients for taking unpopular causes. There are already sanctions systems in place for lawyers who bring frivolous claims. There's something called Rule 11. Rule 11 in the federal court can result in fines against a lawyer who brings a claim that's either he knows to be frivolous or lacks a good faith basis to extend existing law. I wish that Wood had litigated his claims rather than walking away from the bar. What he's done is he's retired in the face of bar disciplinary proceedings rather than go forward, and he's relinquishing his right to practice law forever. For me, that's a chilling message, because I frequently take cases that are designed to press the boundaries of the law. I'm looking to extend law in various ways that serve the interest of our clients. And silencing, marginalizing lawyers who take extreme positions and who try to stretch the law is a chilling thing. And so, I don't know whether Lin Wood was a good lawyer or not. I do know that some of the election interference or Stop the Steal litigation that I read about didn't pass the straight face test. Well, if that's the case, then Rule 11 him. But if his client wanted to advance that and the lawyer took the risk, I think you do something short of just barring him.
Yeah, and I think that it's really easy now to look back and sort of I guess Monday morning quarterback this, but I agree with you, Norm, because I think that you've been outspoken and quite hard on Lin Wood and the other his colleague's name escapes me at the moment, his female colleague. But you were outspoken and criticized them for the manner in which they were sort of marketing the facts that they had within their control over the alleged election interference stuff. So I think that I give you a lot of credit here for the stance that you're taking. This article talks about sort of the timeline of his career. He joined the bar in 1977, so he was coming up on basically 50 years of practice in full. And it also quotes him as saying that he wished this is the outcome that he could have arrived at 2 years ago. Right. I
read that and I chuckled, because typically, if you want to retire from the bar, you can't retire as long as there's a pending disciplinary proceeding, because you could seek to unretire. And so if there's a pending disciplinary proceeding, there is some question raised about your fitness to practice law. And bar disciplinary proceedings are not intended to be punitive. They're intended to protect the public. So in order to protect the public, they want these proceedings to run their course. And so you can't retire because you might decide to come back. And so they want a judgment. So Wood negotiated a settlement, a face-saving settlement that basically says, okay, I quit and I promise never to come back. And the bar regulators thought, okay, that's good enough for us because we've protected the public. And what he's saying is, I would have retired 2 years ago, but these bastards filed these proceedings and the law wouldn't permit me to retire. I mean, a pox on everyone's houses. Let's close the chapter and move on. I just note it with a certain sense of wariness, because lawyers who press the edges are few and far between, and we need to have them.
Yeah, so, no, I definitely agree with that, and it makes me appreciate you more, Norm.
Thank you. Aren't you sweet to say that? It's Friday, and I guess you can afford to say just about anything since we won't talk for a few days. But we are filing, as we speak, in the United States Supreme Court, United States of America versus Edward Lang. It will be the first January 6th certiorari petition filed in the United States Supreme Court. involving a January 6th prosecution. And the question there is whether 18 United States Code Section 1512C2, and I'll be saying that in my sleep for a while, whether that statute can be, which is designed and intended to affect interfering with evidence or the integrity of evidentiary proceedings, can be used against a defendant accused of assaulting a cop in a riot. And our position is it cannot, and it's overly vague. And so this is the first January 6th petition for certiorari to reach the United States Supreme Court. And we wanted to get there first, and we did. So you've got something up there, hot takes. So we've added a new feature in our efforts to influence the world. We're going to soon have a web page that is designed to hot takes, quick impressions on events that put into writing what we say in words to help expand our reach. And the first hot take we did today, Mike posted on Twitter. We're in the process of creating a web page. It's how to understand the affirmative action decisions. So give it a quick read. If you've got a few minutes, spread the word, drive people to law and legitimacy. We're in it for the long haul, and we're in it to win the hearts and minds of ordinary Americans.
That's right. And I think we've got another that I'll publish today as well, but these are live on both Locals. So I've got the call to subscribe to Law and Legitimacy on Locals at lawandlegitimacy.locals.com. That's live there, and it's also live on our Twitter account at Pattis Podcast. And what you'll see here is Norm's, I say from the desk of Norm Pattis. This is his first installment, and he's already got a second in the hopper. So I talk religiously on this platform about how prolific a writer Norm is. We talked about this maybe 48 hours ago, and we've already got 2 written content bursts in the hopper here. So we'll start pushing those. And the second one is going to be really important. We'll do a social media blast about the second one. We really do want to start reaching law students in any phase of their legal education, whether it's on the way to being a 1L, whether it's graduating, from their 3L year and matriculating into the practice of law, or anywhere in between. So when that goes up, we will rely on those of you who tune in daily to reach out to one or more law students that you know. It'll be really important that Norm and I start to begin galvanizing a network of young lawyers in training.
What he said. So have a great weekend, everybody. We'll be back on Monday. We got to do another Sunday session soon with our buddy from XRP, whose name I'm drawing a blank.
Jimmy Valley.
Jimmy Valley. The crypto space is blowing up. Front page story in the New York Times today. Warnings on social media about the move to digital currency. Concerns about digital currency and social control. The SEC is still dilly-dallying around about what to do with cryptocurrencies, whether they're securities or not. Jimmy Valley from Valley Capital in Houston is our go-to guy. We haven't talked to him in about 6 months. Jimmy, if you're listening, we'll be looking for you soon. Make an hour or so for us. We've got questions.
That's right. And we will be back at our normal time, I guess I put 8:30. It's actually 8 a.m. Eastern. So let me fix that before it goes too viral here. But we'll be back 8 a.m. Monday. So that's the 10th on YouTube, Twitter, and Rumble. And this podcast will go up just like all the other ones right after the show is published. And I've gotten a few of you have reached out to me and thanked me for getting these episodes up directly after the stream, because sometimes you're not able to make it. All we ask of you is to rate us 5 stars and to share with one person. It's important to us that those of you who do like tuning in have every available opportunity to listen in. So we'll be back to our normal schedule next week. And I think you and I will be talking over the weekend, Norm, about getting Jimmy Valley on, and then a couple of things that are bubbling here. I think I told you yesterday about an article that showed up in Politico about Europe swinging to the right in response to a lot of the migration, as well as an article that appeared in Vanity Fair about North Carolina's governor race. So I'm really interested in talking about both of those issues, both from a perspective of I'm in the process of reading Camp of the Saints. I don't know what list
Yeah,
that
we're
puts
going to
me
be
on
talking
now.
about Camp of the Saints. I've got a
Yeah.
new hater on Twitter who's accusing me of spreading hate speech because I like Camp of the Saints. I think it's an allegory that explains a lot of what's going on in modern times. And this person says, but the Southern Poverty Law Center says it's a racist book. And my response is, have you read it? Or you won't let the SPLC do your thinking for you. And I think
Yeah,
I know
you know
what
the
the
answer.
answer is there. The
Yeah,
book,
you know the answer to that.
Mike and I have been talking about acquiring the rights to it and perhaps republishing it. We'll talk more about that at some point too.
For sure. Well, Norm, I thank you for giving me the flexibility to move our time this week. It's meant the world to me to be able to spend some time with the family and do what we do around here. And I hope that our viewers have enjoyed a little bit of a change in circumstance. But like I said, we'll be back Monday morning and looking forward to getting these new content bursts out. For everybody to read, and hopefully that'll expand our reach a little bit. It'll give somebody something for people to send to their friends and loved ones that doesn't require listening to a 30-minute segment of a video.
Yeah, or in this case, a 35-minute, 40-second segment.
All right, Norm, have a great weekend. See everybody on Monday.